as Mr. Kilpatrick's announced, the plea in this case would be that you admit your violation of probation, and the agreed-upon sentence would be 3 years in the Department of Corrections to run concurrently or at the same time as the other sentence that you're serving from Santa Rosa County. Is that your understanding?
Yes, Your Honor.
Okay, there's also going to be a $100 VOP or violation of probation fee, but I'll just send that to judgment, so you can pay that once you're released. All right, has anyone forced, I'm sorry, first, is that the agreement that you want to make today?
I think so, yes, Your Honor, yes.
Do you have any questions for me or your lawyer about that?
No, Your Honor.
Okay. Has anyone forced, pressured, or threatened you in any way to enter that plea?
No, Your Honor.
Has anyone promised you anything in return for making this plea?
No, Your Honor.
Do you understand if that you admit that you violated your probation, the state won't have to prove that you violated your probation?
Yes, Your Honor.
Okay. And do you understand there won't be any further hearings on this case?
Yes, Your Honor.
And do you understand that you're waiving any potential defenses that you may have regarding this violation of probation?
Yes, Your Honor.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, Your Honor.
Now, based on everything we've talked about, what is your plea to the violation of probation? Are you admitting that you violated your probation, saying, yes, I did it? Or are you denying it and saying, no, I didn't do it?
No, well, yes, yeah, not tonight.
I'm sorry, what was that, Mr. Jones?
He said, yes, that's fine.
That's fine.
Are
Well-
you admitting that you got arrested, Mr. Johns, Zach?
Yes.
Okay.
Yes, Your Honor. Yes,
So you want to admit the violation of probation?
if I, yes, yes, yes.
Okay.
Okay. Do you have any other questions before I accept your admission?
No, Your Honor.
All right. I'm going to accept your admission as freely, voluntarily, knowingly given. I'm going to adjudicate you guilty. I think he was on the underline already. Sentence you to 3 years in the Department of Corrections. That is a guideline sentence. I've reviewed the sentencing guidelines that show a sentence of 29.250, so it's a little bit above guidelines. So it's not a downward departure. It's a $100 VOP fee that will be sent to judgment. That's to run concurrently with the 3 cases from Santa Rosa County previously announced by Mr. Kilpatrick. I think I said Gilpatrick.
I've been called worse.
Yeah. And then, Mr. Gines, I want to make sure you understand that you have 30 days to appeal the judgment and sentence of the court. So if you want to do that, make sure you file something with the court, and you can try to talk to Mr. Kilpatrick about that as well.
Thank you, Judge Oberliesen. May I be excused, Judge?
Yes, sir. Thank you, Mr. Gines. Have a good day.
Okay.
Yes. Mr. Kilpatrick, do you have those case numbers for Santa Rosa? Can you just step up and give them to the clerk?
Yes, sir. Madam Clerk, those case numbers in Santa Rosa County are 23 CF 1238, case number 23 CF 1253, and case number 23 CF 1878. Thank you.
All right, Mr. Stewart, thank you.
Good morning, Your Honor. May it please the court, Brad Stewart, on behalf of James Carnes. As Mr. Carnes approaches, judges, it's case number 22 CF 1268. Judge, we're before the court with regards to status on pending discovery from our specific demand for discovery. The state has turned over on Tuesday the videos that we anticipated were present. I have not had an opportunity to review those based on my schedule. I anticipate doing that this afternoon and tomorrow morning, Judge. If we could, I believe, set this probably for a contested hearing in the abundance of caution, and we can advance it forward with hopefully with potential movement if necessary.
All right, I've got see, February 26th, I think is getting, it's getting a little full. We can put it there. Otherwise, it would probably be March 5th or March 26th. So I'll give you all the options.
Judge, I anticipate that I'm going to have a week-long trial in Walton County on the week of the 5th.
Okay, that first week of March?
Yes, sir. I
Okay.
believe that's our trial schedule, if I'm not mistaken.
So do you want to do February 26th or March 26th?
I would rather do March 26th, Judge, in advance if we can.
I'm not sure Mr. Carnes agrees with that, based on his reaction. Any issue from the state regarding that?
No, Your Honor, I would just ask that we set it in the afternoon at 2 p.m.
Of
so
course.
that it would be a contested evidentiary.
Has there been an offer extended and conveyed?
I think he has a suspended sentence.
No, he does not have a suspended sentence, Judge. The state has extended an offer, though.
Has it been conveyed to Mr. Carnes?
It has, yes.
Okay. March 26th at 2 o'clock. Obviously, if y'all resolve something in advance, you can advance it on the docket. We may have some other available dockets for purposes of a plea or resolution, but those
Yes,
are the
sir.
ones I have for contested hearings at this point.
Yes, Your Honor.
All right. Thank you.
Thank you, Your Honor. That's all I have. May I be excused? Yeah.
All right, Mr. Durrell.
Your Honor. May it please the court, Dustin Durrell. Your Honor, if I may call my first case today, Mr. Robert Cox.
Go stand on the other side, sir.
And Your Honor, we were set for a motion to modify. In speaking with the state, we've reached a plea agreement in this matter, if I may approach. Yes.
All right, Mr. Cox, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, can you state your full name and date of birth, please?
Robert Cox.
Sir, keep your hands out of your pockets. I know it's a nervous thing, I do it too, but,
Robert Cox, January 27th, 1954.
okay. And Mr. Cox, you're here in 25 CF 2347, where you're charged with aggravated assault with a deadly weapon, which is a third-degree felony punishable by up to 5 years in state prison, and also possession of a weapon or ammunition by a convicted felon, which is a second-degree felony punished by up to 15 years in state prison. Was there an amended information filed on that at some point?
I don't recall an amended. I do know we determined that Mr. Cox is not a convicted felon, though.
Okay.
Yeah.
When I was reading through the case yesterday, I saw the information only has aggravated assault by threat or.
So the state would take no action on the possession of by a convicted
And
felon?
that's the thing, was it even charged by on the arrest?
Arrest. I'm pretty sure I saw it
It
on the
is,
clerk's site. I did not, okay, and I did not look at the information I was working on. Your Honor.
Yeah, it's listed as there, but the information filed on December 29th didn't have that on there, so. All right, so, Mr. Cox, just to be clear, I don't think you were ever officially charged with the possession of the weapon by a convicted felon. Turns out that you're not one, according to what they just told me. So the state's taking no action on that particular charge. All right, now I've been handed a plea and sentencing agreement that would call for you to plead to a lesser included offense of misdemeanor assault, which is a second-degree misdemeanor, and it's punishable by up to 60 days in jail and 6 months of probation. Do you understand that?
Yes,
Just say it out loud. Okay. All right, the plea agreement calls for you to get 6 months of probation, $615 in court costs, no violent contact with the victim in the case, which means, it's not necessarily well-defined, but don't put your hands on someone who doesn't want you to do so. Do you understand that?
Yes, sir.
And no threats or agitation towards someone else.
Yes, sir.
Okay. Is that the agreement that you've made with the state?
Yes, I have.
Is that the state's agreement?
Yes, Your Honor.
All right. And Mr. Cox, did you go over this plea and sentencing agreement with your lawyer, Mr. Durrell?
Yes, sir.
Did you understand the agreement?
Yes, sir.
Did you sign it?
Yes, sir.
All right. Do you need any more time to speak with Mr. Durrell before you go forward with your plea?
No, sir.
And are you satisfied with his counsel and advice in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've
No,
just
sir.
read? You understand that by entering this plea, there won't be a trial of any kind?
Yes, sir.
Do you understand that you're waiving your rights to a trial, which are listed on page 1 of the agreement that you've signed?
Yes, sir.
And do you understand that you're waiving any potential defenses that you have to that charge?
Yes, sir.
Do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
And this is an adjudication of guilt as well, correct? All right. All right, Mr. Cox, what is your plea to the misdemeanor assault charge?
Guilty. No contest.
The form that you've signed says no contest, so I'm going to
Yes.
accept your no contest plea as freely, voluntarily, knowingly given. I'm going to adjudicate you guilty of the misdemeanor assault. 6 months probation. I believe the court cost would then only be $270, or is there more because it's an assault charge? Assault and battery in the same statute. $784.011. Court cost will be $622, Mr. Cox.
Yes, sir.
$7 more. Does that change your mind in any way?
No, sir.
Okay. Also, there'll be a cost of supervision for probation for $40 per month.
Yes, sir.
All right, Mr. Cox, I'm going to have you meet with probation, who's sitting at the table behind you, and then you have 30 days to appeal the judgment and sentence of the court. I don't believe assault is, so I don't need his fingerprints. And obviously, there's no guidelines. Is this a misdemeanor plea? All right. Meet with probation, Mr. Cox. You have
Thank you.
30 days to appeal.
I have Mr. Jonathan Jones.
All right, this is Jonathan Jones, 25 CF 2195. I believe we're here for a motion to modify pretrial release.
Honor, this was a motion to modify to allow no violent contact with the victim based on the statement made by the victim in that drop charge request. Prosecution would like Mr. Jones home. Of course, Mr. Jones has been picked up on different charges in the meantime.
Are those in this division as well?
I believe so, Your Honor. I believe it was rather recent. I don't know very much about it, to be honest.
Are you wanting to go forward with that motion still?
If we may, Your Honor.
Sure. The state's position on the motion?
We'd object. The statement provided by the victim is vague as far as, I don't know what statement she says she's recanting. And furthermore, there are witnesses alleged and that the state has provided the defense that witnessed the crime. So we would object.
When are the new charges from? 'Cause I don't see them.
When you get picked up. I believe he was arrested on the new charges just this week, Your Honor. I believe they are alleged to have occurred within the last 30 to 60 days.
I don't know anything about the charges. I don't know if they involve the same person or even what the charge is.
It's my understanding, Your Honor, that this is a different individual. It's Mr. Jones's, it's your ex.
Soon-to-be ex-wife. I kept my son 2 hours later than I was supposed
I
to.
wouldn't talk about the facts of your case, Mr. Jones.
It is a custody issue, I believe.
What's the
Some kind
charge?
of
Because
injunction.
it's
It's
not even
contempt of
showing up
court.
in the jail site yet.
So, yeah,
Do you have
I
any
know-
information about the new case?
I don't have any information about that. I mean, I can look in the DR case, possibly in the DR case.
I believe it's a violation of injunction, Your Honor.
Has the state had any opportunity to speak with the alleged victim in this case?
I can look at my notes. Given that she's asking to drop the charges, and given that he's picked up another violation, although it's not a new law per se, it just shows that he's not going to obey court orders.
Given the facts of the two being completely separate. And I do know, based on what the victim has told me and what she put in her statement that submitted with the motion today, she said she wants nothing to do with the prosecution, is not going to speak to anybody from the state, even if they had attempted to call her. I don't, based on the information I have, she's not even going to talk to them.
Where does this form come from that she filled this out? Is that a form that you use, Mr. Drew? Just,
The statement, yeah, I just have a blank affidavit form.
because my concern is usually, you know, when someone comes in to testify that they want to have contact, there's a little bit more to it as far as making sure that they haven't been forced, pressured, threatened, promised anything.
If you recall, we had this issue, I believe it was earlier, and she filed or gave me a form that was not notarized. I had spoken to a liaison. I actually have not spoken to her directly. She didn't even want to come into my office. That's how removed she is from this whole thing. So I didn't have a chance to really speak with her, go over any of that. That's what was handed to me after she had it notarized, Your Honor.
Because, to be honest, I can't even read the signature. And there's nothing on here indicating how the notary knows who this person is. It doesn't say they looked at a DL, that they're known to them. So I've got some concerns about.
That's why I like them to come into my office, but she was refusing to do so.
Okay. So I'm gonna need her to either come in and testify that she wants contact or have a proper notarized, more robust statement, because as the state's pointed out, she's not even really saying what she wants, other than she doesn't want to go forward, but she's not even referring to who she's talking about. It's got her name printed on the top, but it doesn't even say Mr. Jones' case. I have no reason to believe that it's not related to this case, other than it's just, she doesn't put it in there, doesn't mention a name. The case number, the style of the case is not on the page that she signed. It's not properly notarized. To be honest, I'm not sure who this person is who notarized it, but they should know better. The other issue is I don't really know anything about this new case yet. I'm not sure why it's not even appearing in the jail website. The jail has released it back in November. It doesn't even show him in jail right now. I don't know if there's a different spelling of his name.
If I may, Your Honor, the jail's old website just got re-put up. Our office has also had issues finding people, so I believe it's just perhaps the same as the clerk's website, where information needs transferred or information is not being processed as fast as it should.
So let me, thank you, Mr. Maddox.
Yes,
As a
Your
friend of the court, I appreciate you telling me that. So as far as we're hearing now is the jail's website, we can't even trust that the information is updated to the point we know who's in jail and who's not. Is there any information that comes out on that roster as to why they're there? There's no clerk number.
And I don't know which DR case it is, because there's a few.
I'll take a look at it later, but thanks to you. Is there a DR case here?
What I have is, it looks like it's a dissolution with children in front of Judge Gonter.
What's the case number on that? Maybe I'll see if there's a different spelling of his name there. Mr. Jones, I'm gonna figure this out.
I have 25 DR 89.
And just so you understand, Mr. Jones, Mr. Durrell, I'm not looking into that case other than to see if I can link that somehow to find out what else is going on here, because
Right.
there's no other information. And if I had all the information I need right now, I can make a better decision, but I seemingly don't.
All I see, Judge, is there's a notice for trial. I don't see like an order related to taking somebody into custody for a violation.
For this, give me a new one. I can't make
At this time, I'm going to deny the motion to modify without prejudice to bring it back once you have the information, as I've talked about, Mr. Durrell. I'd certainly like to know if there's any other conditions of any release that he's going to have. Does he not have a bond on the new case?
He does have a bond. There's a $2,000, I believe, signature bond on Wednesday morning. And then they revoked the bond on this case, obviously, when he came in front of them on the case.
And that's what I don't know as well, is because you said it happened in the last 30 to 60 days, but he just got arrested, so I'm not sure versus when this happened, versus on the allegations of that, if it's something that would have revoked his bond or not. I'm assuming the first appearance judge had that access to that information a couple of days ago, or you said yesterday, Wednesday?
Wednesday, yeah.
So, and that's the problem. By the time that paperwork gets processed, it could be days. I'm certainly willing to reconsider it if you can get all the information I need, but the big issue is either having the alleged victim here to testify, or having a properly notarized statement that has some actual information related to the case on it as well. Okay.
If I may, Judge, I'm looking at the first appearance paperwork, and I have a violation of domestic violence injunction, $2,000 cash and professional.
Okay. And you're able to see that in your system?
I just have the first appearance paperwork that's sent out by the jail. So it's like a roster.
Oh, like the one-page sheet, or sometimes two, depending on how many
Yes,
people
it's
get
like,
arrested?
it's what the attorneys get in the morning.
We're gonna have to have some conversations. All right, so again, bring back the motion if you can get that information I've talked about, and I'll certainly reconsider it as soon as you can do that. All right, thank you.
That's all I have, Your Honor.
Thank you. Mr. Voss? This is going to be Tremaine Parker, 24 CF 2270. It's a violation of probation, but he's here on a bond hearing.
That's correct, Your Honor.
All right, go ahead.
Mr. Parker has a violation of probation. However, he does not have a bond, and I understand when it's a violation of probation that it's not. However, Mr. Parker, the violations are all technical in nature. He is really trying to better his life and stuff, and he has 3 children that he needs to pay alimony for, child support for. He does have a job when he gets out. He'll be going back to Gulf Cable. His priors are a long time ago, and I need to talk to the state about his priors because I don't know when they were, and we are talking to, we do need to talk to the state about those. He does have a place at the Milton Reeb, R-E-A-B, when he gets out, so he does have a place to stay. He's never had a failure to appear, and he's not had any issues while he's in jail. The court, when the defendant may be admitted to bail pending the resolution of his violation of probation hearing or violation of control, community control hearing. And when the court needs to determine whether to set the bond, there's several factors that the court can look at, the nature and the circumstances of the violations. And as I said, those violations are technical. They all have to do with him either missing an AA appointment, missing an appointment with his probation officer, and then within a 41-minute time frame, he was on an electric monitor, and it went off, I believe, 5 or 6 times. Well, he had gone and he was sitting outside, and the part fell off of his belt. When he went inside, he sat down for a minute, and he fell asleep. And he did not know that the monitor was not with him. It had fallen off and was in the chair outside by the fire pit, and even the probation officer says that's where they found it when the probation officer got there. He has family ties to the community, Your Honor. He has 3 children, again, as I said, that he needs to get out and so he can start paying child support for so that the children can have the things that they need. Right now, I don't believe that the mother of the children has enough money to take care of them, so she needs that. His employment history is good with the Gulf Cable. The problem is that he worked from 7:30 p.m. to 7:30 a.m. And that's what caused him to miss all of the appointments and to fall asleep. It was his new job. He hadn't gotten himself acclimated to it enough where he would get up after he got home from work.
Well, here's the thing, Mr. Bass. He pled in March, right? It was a downward departure.
Yes, Your Honor, I
He scored
understand
prison.
that. I understand
And
that.
now he's here saying, I'm not able to get up to go to my AA meetings, which were a requirement of that community control. That's a problem. All right, state's position.
Your Honor, the state objects to a bond in this case, exactly for what the court just mentioned. It was already a downward departure. Additionally, he had violated the condition of probation, and as an alternative sanctioning program, he agreed to have the GPS monitor for 45 days. He was on community control. Additionally, it appears from the violation report that he was untruthful with probation. He apparently underwent a substance abuse evaluation, and it was deemed that treatment was not necessary. However, apparently insisted on going on those AA meetings, although probation had not permitted him to do so. He was also ordered to complete a battery intervention program class, and according to the report, he hasn't even registered for one. It's the state's concern that obviously is a flight risk. He wasn't able to abide by the conditions of the electronic monitoring. He lied to probation. And obviously, again, he's on probation for violent crimes. So the state is concerned about the safety of the community and to ensure his presence. The offer currently is for revoke and terminate probation and 45 months DOC.
If I may.
Hold on just a second. I'm reviewing the affidavit. All right, go ahead. So I just wanted to read, the pages were, for some reason.
Okay, thank you, Your Honor. As for the AA meetings, he had asked his probation officer, Your Honor, if he could go to 5 meetings a week. The probation officer denied that and let him know that he could go to 3. He also voluntarily went to rehab so that he could
The
get...
issue is he wasn't at one when probation went to check to see if he was
Right,
there according to his community control schedule.
Yes, and I understand that, and again, it was just because he was not acclimated to his new job hours, And, you know, he knew that he was going to get arrested for the violation. He contacted my office, and he still went to probation on the day he was scheduled to go, even though he knew he was going to get arrested, because he did not want, he wants to get better. He wants to straighten out his life, Your Honor, and he's really trying to. And those technical violations of just, you know, falling asleep, missing, and he did try to call the probation officer late, I would say, but he did try to call the probation officer, as she listed in her report, on the day that he missed his appointment with her. So he's trying, it's just with the acclimation to the new job is what caused the problems. So
When did he start the job? Because the issue is, there was an alternative sanction of the 45 days because there was a technical violation, which was the original missing of the AA. And so then he was given another sanction, and then he has issues with that sanction. That's what my concern is. This is not like it's the first time that it's come to the court's attention, because I allowed him to do the 45 days
Yes, Your
of
Honor.
electronic monitoring, and he's having problems with that, where it appears that he left the device outside when he went back into sleep, according to him. But that involves someone coming out in the middle of the night to check as why it was showing up his bracelet gone alarm. And that's not the way this is supposed to work.
And it was only 3 days after, Your Honor, but as I said, he did tell the officer that he left it outside, but he did not know that he left it outside when he went inside. It had fallen off of his pants.
But it's his job to make sure it doesn't do that.
Yes, I understand, Your Honor. We're just asking for a bond to let him get back out and start working and taking care of his kids. He's not a flight risk, Your Honor. As I said, he did turn himself into his probation officer.
Where is his family law case?
Excuse me?
Does he have a family law case?
No, Your Honor.
So he's not court ordered to file any support? Is he married?
Yes, sir.
Mm-hmm. To the alleged victim.
Has the state reached out to her at all
Yes, Your Honor.
since the VOP or no?
Actually, even right before it was violated. And, I mean, it would be improper of me to relate what the victim said to me. However, I can indicate that she would not be okay with his release on bond.
All right, given the circumstances, this was a downward departure, there was an alternative sanction already done, and there's still issues with following it. I'm not going to grant a bond at this time, so the motion is denied. Thank you, Mr. Pires.
I believe, Your Honor, we're already set for an evidentiary hearing, I think on the 26th.
We are.
26th of February at
26th
2 o'clock.
Yes.
All right, we'll see y'all back then.
Thank you, Your Honor. May I be excused?
Yes, thank you. Mr. Crawford?
I'm here on behalf of Mr. Dreddy. I don't believe the,
Just got your email this morning.
perfect.
There's a substitution of counsel, Your Honor. I just need to sign that form and get it back to the court.
I think we were here last week, and that was the issue.
Yes.
Have you had a chance to speak with him?
I spoke with his family.
You have dreading? Do you want to speak with him in the back room before you bring him out?
I do, because we have a little bit of a complication that we got to address.
Okay, why don't you talk to him, and I'll call you back up once you're ready. Thank you, Mr. Crawford. Actually, can I get Davis? Yes, he is. I just turned left, sir. All right, Mr. Ramey, are you on Zoom?
I am, Your Honor. Good morning.
Oh, there you are. All right, we're trying to get Ms. Davis pulled up from out of custody.
Yes, sir. Thank you.
All right. Ms. Davis is now here in the courtroom. Mr. Ramey, her attorney, is on Zoom. This is 23 CF 2800, 2826, 24 CF 1060, and 24 CF 1535. I think we're here just about status regarding drug court. Mr. Ramey?
Yes, sir. I have sent a consent for receipt of the case to Ms. Flowers, which she's executed. Waiting on the state attorney in Bay County to sign his consent and authorize the order to go to Judge Stevenson. His secretary indicated to me it's on his desk ready for signature. So we're hoping that I get done today, and in talking with Ms. Oliver, she's hoping to get her in drug court next Wednesday. So hopefully we'll have all that documentation over and filed sometime today or tomorrow, and give the clerk time to transfer the file so everything can move forward on Wednesday as planned by Ms. Oliver.
Okay, when you said Judge Stevenson, that's from Bay, he's from Bay County, he or she's from Bay County?
Yes, sir. That's Dustin Stevenson from Bay County Circuit Judge.
I know the name, but I'm not familiar. I just wanted to make sure I was getting that right from you, Mr. Ramey. All right, so what do you want to do with the case until Wednesday? I mean, I can give you a status date with me just to make sure it doesn't fall off the docket if things don't go the way they're supposed to on Wednesday.
Yes, sir. I'd like to have that backup just in case.
All right, state have any objection?
No objection.
All right. And everything accurate as far as Mr. Ramey said, you're just waiting on that paperwork to go through? Okay.
Yes, sir.
All right, so we'll put you on, the next miscellaneous date I have is February 26th at 9 o'clock. However, if you plea into drug court next week, you'll be taken off my docket and you'll continue to
I
do
don't
drug.
remember that court date when I plea out there.
If you plea out there into drug court, you wouldn't have to come back here for the 26th. Yes. All right. Thank you.
Judge, thank you. That's all I have. May I be excused?
Yes, Mr. Ramey. Thank you.
Thank you, Judge. Great to see you, and thanks for allowing me to appear by Zoom.
All right, I hope you're doing better.
Making progress. I'm hoping I'll be able to drive in 3 weeks.
All right. I'll hold you to it.
I look forward to seeing you in person.
All right, thanks, Mr. Ramey.
Bye-bye.
All right, that's all I had on Zoom. I'm going to go ahead and close that down at this time. All right. Who do you have lined up? All right,
I am.
Let's do those then. I think Ms. Alford's here.
Judge, the one I have out of custody is Alford. If you'll recall, we had, I believe, Dr. McDonald do a report, and the court already has that. The state asked for APD to be appointed. APD was. The court, at our last court date, instructed me to follow up with APD. I did so. We have a report from APD at this point.
And I received that a couple of days ago, and I've reviewed that.
Forwarded to the court, so I think we're ready to proceed today.
Just for the record, that's from psychologist Rachel Charlepp, SCHARLEPP.
Yes, sir.
All right, have y'all reviewed that?
I have, Judge.
Okay, the state has, Ms. Flowers? Okay.
Yes, Judge.
All right, and the recommendation there was for basically outpatient APD services, correct?
Judge, that was her recommendation in term. The way that I took it was sort of we're not really sure that will help, but we can give this a try. The court will recall Dr. McDonald, I believe it was, found that she was not capable of being restored. But we'll stipulate to the admissibility of both reports so that the court can make a decision on it.
The state would also stipulate to the admissibility, and the state would be requesting, as the court stated, the competency training as recommended in that second report, and set for a status hearing after that's been done.
And I'll accept the reports and the stipulation that the court can make the decision based on those two reports, which I previously reviewed yesterday again. I think Dr. McDonald didn't necessarily say that she's unrestorable, but if you read between the lines, that's potentially going to be what it turns into.
Yes, sir.
But based on that, I would like her to engage in the outpatient services with APD as recommended by the second report. And just to put it out there, Dr. McDonald also said that APD should be appointed by the court, so to determine her appropriateness for restorative or restoration services offered by APD. So I'm going to order that at this time.
Yes, sir. Judge, I have in the file what appears to me to be in order. Does the court have a draft order from us already on
I
this?
do not. So if you could just email that to Ms. Rhodes, and I'll
Yes, sir.
look at it once it goes into my queue.
All righty, Judge. All right, thank you, sir.
Thank you. All right, thank you, Ms. Alford. As far as a follow-up date, do we want to put it about 6 months out?
That's what I'd suggest, Judge.
Just to see how things are going, Ms. Alford.
Yes, sir.
Let's call it, let's do August 6th at 9 o'clock for purposes of a status on the restoration services with APD.
Judge, you'll handle other matters for a moment.
Sure, that's fine.
Thank you, sir.
All right. Mr. Crawford, are you ready now?
Yes, Your Honor.
All right, Mr. Redding?
May we approach very briefly on Mr.
Yes, sir. Yes, sir. Who's the state on dreading? Ms. Leone, are you?
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
All right, based on the discussion at the bench, Mr. Dre, what we're going to do is we're going to put you on my next possible court date, which is actually 3 weeks from today. However, if everyone gets it resolved and it's going to lead to your release, I'll find another day before that to get y'all in to get that plea taken.
Court date is the 28th.
So it's February 26th at 9 o'clock.
But he's going into a 2-week civil trial weekend.
On the 28th?
No, figure it out. Okay. The 28th is just like that's the next scheduling date.
It'll be the 26th. at 9 o'clock.
26th.
That's 3 weeks from today, but again, we'll find a way to make it work in the next couple of weeks if there is a plea that resolves the case.
The draw, if they don't want it.
January 9th is when you pled over there?
7th.
7th, yeah. So within a 60-day window.
Okay.
It's January 7th.
All right, appreciate
All right,
it.
thank you all.
Thank you.
All right. Ms. Dudley, are you ready?
Your Honor, this is George Scott in 24 CF 2605. There's a motion to reinstate bond. I've spoken with the state. The state is in agreement to reinstate the bond based on our communication about resolving the case.
Was the case going to be resolved?
We're waiting on some more information as far as restitution goes. We want to make sure we have all that before we actually enter the plea.
That's correct, Your Honor. The state is not seeking an incarcerative sentence on this case, so that would be the reason the state would stipulate to reinstating the bond. We are anticipating getting a plea entered that would be probation with, we're just wanting to work out the actual restitution amount so that it's part of the order when he actually enters the plea rather than reserving.
Does he score? He does.
Yes, sir.
It's going to be a downward departure as well.
It would be a downward departure based on a negotiated plea and the need for restitution over incarceration.
So the victims in the case are asking for that?
That is my understanding. That's why we're setting it off for me to confirm. I've been reading notes in the file, so I just want to confirm myself.
What was his bond initially?
The bond was $5,000 cash professional, $2,500 on the DUI, $2,500 on the leaving the scene, and then a $1,000 signature on the resisting.
I don't have any idea what the restitution is going to be.
Right now, it shows like around a little over 2,000. Just want to make sure he's okay with stipulating to it. It's just making sure that there's not anything additional before we actually sign. The concern is if we reserve on it, sometimes it falls through the cracks. We just want to make sure we have it up front.
Reinstate the previous bond amounts. It's $2,500 on each of the two felony cases. $1,000 signature on the resisting, based on state's agreement.
And is
that
he-
would change his pretrial date from 2/25 to 2/23.
Yes, sir.
So, Mr. Scott, your next court date is going to be February 23rd at 9 o'clock. Make sure you're here.
Thank you, Your Honor.
That's all I have, Your Honor.
All right, thank you, Ms. Dudley.
That's all I have, thank you.
What do you have?
On up, Mr. Marshall.
This is Andrew Marshall,
This is Judge.
5 CF 1667.
That's correct, Judge. He's got a new law violation, 26 CF 191, that I believe is on for the 26th. I'm going to enter denial at this time and ask that the case is tracked.
That's his arraignment date.
That's what I have, Judge.
Okay.
I
All
don't
right.
think any information's been filed yet.
Denial's been entered. Let's put it on the February 26th at 1:30 to run with his new law violation.
Thank you, Judge.
All right, we'll see you back on that date, Mr. Marshall.
All right, Mr. Marshall. You too. Hey, Mr. Owens. Judge, Mr. Owen, this is Charles Owens, 21 CF 2984. We had tendered a counteroffer to the state. Right now, the state's offer is 4 years. The state's not accepted that offer, so what I'd like to do is schedule it for an evidentiary and set it for the next.
No objection to that, Judge.
If we get it worked out before then, we'll take care of it, but it doesn't look to me like we're going to.
I want to do February 26th,
Yes, sir, 2 p.m.
2 p.m.
Yes, sir.
2 o'clock with subpoenas.
Yes, sir.
All right, thank you, Mr. Owens. We'll see you back on that date.
All right, sir.
I may, Your Honor, I do have one out of custody, if I may call that case first.
That's fine.
Rebecca Glover. Your Honor, this is Ms. Glover before the court in 21 CF 939. The court graciously granted our motion to withdraw the capias. We thank the court for that.
That was just the one that was added like yesterday or something.
Correct, Your
Okay,
Honor.
that's why I couldn't find it.
Um,
Go ahead.
We have a resolution worked out in this case pending Ms. Glover's payment of her court costs. I've spoken with the probation officer. I've spoken with Ms. Flowers with the state. It's going to be revoke and terminate, Your Honor, time served. She's going to get her, was it a disability check or something like that? Okay. She's going to be getting a check soon, Your Honor. She's talked with her probation officer. She's going to be paying those costs. She should be able to get those paid by the 12th, and then we can work this case out. Could we put her on 2/12 for resolution, Your Honor?
I don't have anything on the 12th.
I thought you had an arraignment date on the 12th, Your Honor, or a miscellaneous.
I think that's the problem, is they listed her for the 12th, which is not a day that I have an arraignment docket.
Oh, interesting. It was on our, okay, well, I would have put that in the motion. I didn't even realize that when I was looking at my own calendar. Okay, what's the next available date the court has?
2/26.
Okay, we'll
The
take
next 2 weeks are
2/26.
my civil jury trial week, so I don't
Yes, Your
typically do anything other than pretrial detentions those weeks, and unless it involves someone being released from jail or something time sensitive, I typically don't put those in the middle of a trial, just because, as y'all know, trials, although fluid, do need need a lot of attention. So.
Yep, so the 26th would be fine, Your Honor, thank you.
All right, 2/26 at 9 o'clock, Ms. Glover. We'll see you back on that day.
Thank you, just bring a receipt for the court costs.
It wasn't clear, the KPS is withdrawn. I think I signed an order yesterday, just want to make sure it's clear.
Thank you, Your Honor. And then, it's not on the docket today, Your Honor. I did just want to bring this case to the court's attention. Damian Crooks, he's still being held in the jail. They have
Signed
received.
that order.
Yes, I know
At
you
least
did.
a couple days ago.
Yes, I've talked to the jail. They won't release him because the clerk has yet to send over a CVF form, which DOC requires to process his release. So the jail won't release him. DOC won't certify his release. All I need is that form to be sent, however that is sent, so that he can be released. It's called a CVF. I'm not.
I think you have to talk to the clerk's office, Mr. Maddox. And
Okay. I'll get with them on
I
that.
think I've said it enough over the past 7 to 8 months that the court has no control over the clerk's office and their.
Understood.
or at least very limited.
But I did see your signed order, so thank you, Your Honor. Your Honor, this is Mr. Stephen Arp before the court in 22 CF 1833. Your Honor, I am asking for a continuance in this case. I've spoken with Mr. Arp and the state. They have no objection to the continuance. We do continue to get the character letters in, Your Honor. I've received those. I've requested Court Smart from his sentencing date because I'm looking into something with that. And then I am continuing to research the case, Your Honor. However, with all that said, I do anticipate knowing what we'll do on that date, and then if we don't resolve it, setting it for a hearing after that date, Your Honor, if necessary.
What date did you want?
The next miscellaneous, is that the 26th? Yes, Your Honor.
All right, 2/26 at 9 o'clock. Without subpoenas?
Yes, Your Honor, without. All right, we have a resolution in this case. This is Mr. Ottman before the court in 24 CF 1777, Your Honor. I would point out to the court that this is Mr. Ottman's first felony conviction as a result of the probation being revoked and terminated. I've spoken to him about that. He is fine with this agreement. It is signed by all parties. If I may approach, Your Honor.
Mr. Ottman, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
Jeremy Payton Altman, 6/16/2000.
All right, Mr. Ottman, you're here in 24 CF 1777, charged with a violation of probation. Do you understand that?
Yes, sir.
I've been handed a plea agreement between you and the state that calls for you to admit your violation of probation. Your probation will be revoked and terminated. 90 days in the county jail, credit for time served. The state is stipulating that you have that credit in, is that right?
Correct.
All right, $100 VOP fee, $150 cost of defense, adjudication of guilt. Then I'll give you 90 days to make your payment of those costs. Is that what you want to do, Mr. Ottman?
Sir.
All right, did you go over this form with your attorney?
Yes, sir.
Do you need any more time to do so?
No, sir.
Did you understand and sign it?
Yes, sir.
And are you satisfied with your attorney's advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this
No,
plea?
sir.
And has anyone promised you anything other than the terms of the agreement that I just announced? Do you understand that by entering an admission to your violation of probation, there won't be a hearing where the state will have to prove that you violated?
There's no hearing.
There's not going to be a hearing
Yes, sir.
where the
That's
state
fine.
would have to prove how you violated,
Yes, sir.
specifically
That's fine.
using methamphetamine and marijuana.
Yeah.
Okay,
Admit to it.
okay. And do you understand that you're waiving any potential defenses that you may have?
Sir.
And do you understand that you'll be a convicted felon now because of this?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
And what is your plea to the violation of probation? Are you admitting or denying it?
I'm admitting.
Accept your admission as freely, voluntarily, knowingly given. Adjudicate you guilty, revoke and terminate your probation. 90 days county jail, credit for time served. There's a stipulation that you've served those 90 days. $100 VOP fee, $150 cost of defense. I'll give you 90 days to pay those or set up a payment plan with the clerk's office. This is a guideline sentence as he only scored 10.2 points. I do need you to be fingerprinted, Mr. Ottman, and you have 30 days to appeal the judgment and sentence of the court.
Yes, sir.
Yes, Your Honor. Thank you. All right, good luck, sir.
Chapman.
Your Honor, you did sign an order relieving the public defender on this case. I believe we had a conflict in the case and withdrew.
I recognize the name from recently. So is RCC appointed?
I believe so, Your Honor.
Mr. Klein's here today? Okay. Why don't we bring Ms. Chapman back once Mr. Klein's is back so that he can know he's been appointed to it and they can discuss anything if they need to. So Ms. Chapman, we'll bring you right back with your new lawyer in a minute.
Thank you, Your Honor. Mr. Cole. Your Honor, this is Mr. Cole before the court in 25 CF 1924. We have reached a resolution. I've also reached out to the state over in the south end, Your Honor, and we've reached a resolution on those 2 misdemeanors if the court has no objection to taking that resolution. Okay.
Which division is that?
It is in...
Oh, so it should be Judge Reed's division?
Yes, Your Honor, it'd be Judge Reed's division. It's 2 misdemeanors. It's a trespass and a resisting time served agreements.
The prosecutor from that division is checked off on this?
Yes, Your Honor.
Fine with me then.
All right. May I approach then?
Yes. All right, Mr. Cole, raise your hand to be sworn. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
All right, can you state your full name and date of birth, please?
Slater Glenn Allen Cole, February 9th, 1993.
All right, you're here in 25 CF 1924, which is your violation of probation in my court, but then you also have 2 misdemeanors, 25 MM 3354, which is a trespass, and 26 MM 100, which is a resisting without violence. Do you understand that?
Yes, sir.
Both of those are misdemeanors, so you can get up to a year in county jail for those. That's not the agreement, but you understand that's the maximum.
Right. Possible.
Okay.
Right.
All right, so Mr. Cole, I've been handed a plea agreement for those 3 cases that calls for you to admit your violation, the violation of probation case, 90 days county jail, credit for all time served, adjudication of guilt, $100 VOP fee, $150 cost of defense, revoke and terminate your probation, and all your costs to go to judgment. In the misdemeanor cases, it'll also be adjudication of guilt, credit for time served, $270 in court costs for each case, and $100 cost of defense. And I can give you 90 days to set up a payment plan for that.
Yeah?
Yeah.
Okay.
Okay. Is that what you want to do today, Mr. Cole?
Yeah, yes, Your Honor.
Okay.
Yes, sir.
All right, so Mr. Cole, I do want to mention one thing. I'm looking at your guidelines. Right now, you score 41.40 points. What that means is if you were to come back on another felony case, you might score prison. Do you understand that?
Right, yes, Your Honor.
So we don't want to see you back, right?
No, sir, I won't be back.
You don't want to be back?
No, sir.
Okay.
Amen.
All right, well then, just make sure you understand that
Yes, sir.
because you've got a little bit of history here.
Man, yes.
That's
Your
okay.
Honor.
I'm just making sure you understand.
Yes.
Right.
So things may be different next time if you come back. I just hope that doesn't have to happen.
Right.
Us
No,
too, Your Honor. Thank you.
Right.
Okay, Mr. Cole, have you gone over this plea agreement with your lawyer?
Yes, Your Honor.
And did you understand it?
Yes, Your Honor.
Is that your signature on there?
Yes, Your Honor.
And did you need any more time to speak with your lawyer?
No, Your Honor. But I appreciate y'all very much for your time, man. I thank y'all for serving and protecting us, Thank y'all
you, Mr. Cole.
for giving me my freedom and liberty. I appreciate y'all for the justice.
Are you are you satisfied with your attorney's advice and counsel in this case?
Best attorney I ever had, yeah, for real.
Well, who's it?
Mr. Cole.
I'm not going to ask who the county court PD is.
Yeah. God bless y'all, man. Thank you. You're the best judge I ever had, Mr. Judge David. God bless y'all, man.
I hate for the next question to be this, but in order, the next question is, are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor, no.
Just answer no again, just because he needs to finish.
I ask these questions of everybody, Mr. Cole, so just answer the questions.
Right.
Are you currently suffering from any mental health issues?
No, Your Honor.
Okay, and has anyone forced you to take this plea?
No, Your Honor.
Has anyone promised you anything to take this plea?
No, Your Honor.
And in the violation of probation case, do you understand that if you enter an admission, there won't be a hearing where the state would have to prove how you violated your probation?
Right.
And do you understand that in the 2 new misdemeanor cases, that if you enter a plea of no contest, then there won't be a trial of any kind?
No, Your Honor.
You don't understand
No,
that?
I do.
You do understand that?
Yeah, yes, Your Honor.
Okay, you understand there will be no trial?
Right, yes, Your Honor.
Okay.
Yep.
It's gonna be,
Praise
yes, we have
God.
no bananas, right? So,
Yep.
all right, Mr. Cole. Do you understand you're waiving any potential defenses that you may have?
Right. No, Your Honor. Wait, what's the question? I'm sorry.
Do you understand you're waiving any potential defenses?
Oh, yes, Your Honor. Yes,
Okay.
Your Honor. I'm sorry. I'm sorry.
Just take it slow. Listen to the
I'm
question. All right, and in the violation of probation, are you over here, Mr. Cole?
Okay.
Okay. Are you admitting that you violated your probation, or are you denying, said, no, I didn't?
No, I did. I do admit that I violated. Yes, Your Honor.
Okay, you've admitted. And on the 2 new misdemeanor cases, the trespass and the resisting arrest without violence, what is your plea? Guilty, no contest, or not guilty?
No contest.
All right. I'm going to accept your admission to the VOP as well as the no contest plea to the 2 misdemeanor counts. In the violation of probation, 25 CF 1924, 90 days county jail, credit for time served, adjudicate you guilty, $100 VOP fee, $150 cost of defense, revoke and terminate your probation, your costs will go to judgment. And on the 25 MM 3354 and 26 MM 100, it's going to be an adjudication of guilt. Credit for time served, $270 in court costs for each case, and $100 cost of defense. I'll give you 90 days to set up a payment plan on that, Mr. Cole. And then I don't think I need him to be fingerprinted, but you do have 30 days to appeal the judgment and sentence of the court.
Can I ask the payment plan, or what's going on with the money?
You just got to come into the clerk's office within the next 90 days and set that up.
Set up a payment plan?
To pay off your court costs.
Okay, okay.
It's going to be about $640, plus you're going to have a judgment for you on the VOP case as well.
Right, so if I couldn't make a payment, y'all work with me like for some way?
The clerk's office will work with you about that.
Okay, I got 90 days. What happens if like it didn't happen within 90 days?
Could suspend your license, stuff like that.
Okay. That's
Make sure you do it, and if you have problems with it, you know.
Right, that's when I get out. That's what I plan on. Yeah, I definitely need to get my driver's license back. And that being said, that's what I got to do with Escambia, Santa Rosa. I got to set up a payment plan with the clerk's office in order to obtain my driver's license again already as it is. So.
All right. Don't let this stuff snowball on you, Mr. Cole.
No, man. I'm about to, man, you don't even know how much I appreciate y'all, man. I'm about to get out of here and further my education and try to become a welder, man.
That sounds like a great idea.
I already got my twit card. So.
All right. Thank you, Mr. Cole.
Hey, man. God bless y'all, man. Thank y'all so much. Thank you, Your Honor. Thank you so much, Mr. Glenn. Nice to meet y'all. I'll be around. I'll see y'all out there, man. Y'all stay connected. Jesus loves y'all.
All right,
I'll
thank
work
you.
with you. I'll work for you.
All right. Thank you.
Hey, God bless y'all. Thank you. God bless y'all, man. I love y'all, man.
Nicest guy you'll ever meet.
All right. This is Austin Geis, 24 CF 2576.
Yes, Your Honor. Your Honor, this is Mr. Austin Geis before the court in 24 CF 2576 and 25 CF 375. Your Honor, we do have a resolution. Our intention is to revoke and terminate the misdemeanor probation that he's on and then put him on a year of CC and complete the original terms in 24 CF 2576. One thing I did want to clarify, Your Honor, because I couldn't access the plea agreement that we had originally had, and I believe I wrote it up, so I don't have a copy with my office or anything, but it's not on the clerk's website. I just want to make sure Mr. Geis understands the conditions that are on his probation. My understanding was that in 25 CF 375, that's the misdemeanor battery case, Since we're revoking and terminating that probation, those conditions will be, waived. And then in 24 CF 2576, he would just need to complete the conditions of that probation with, of course, the understanding that the no violent contact provision with Miss Tiffany Hunter would still stay in place. Is that the court's understanding, or is the court
I don't have
able-
an understanding. I haven't seen the plea agreement.
Right, I'll bring that up, Your Honor. Are you able to see the original plea agreement? Because I was not.
In the 24 or the 25 case, or is it the same?
It resolved. So, Judge, I've just spoken with the state. They're required. So, Your Honor, never mind on that. He's just going to need to complete all conditions as part of his probation. So I'm going to fix something in this plea agreement here, Your Honor, just to make that clear. But the court does not need to go over that.
Are these my only
The state, and
Yes.
just to clarify, the state's intention would be that because the recommendation with probation was to put him on more, the stricter community control, but we couldn't do that obviously on a misdemeanor. But we still wanted him to do those conditions that were on his misdemeanor probation, but just roll them over into this new felony case so that it's all in one. Same conditions, just on felony probation.
Initial that for me, sir. All right, sorry for the confusion on that, Your Honor.
I don't see the plea agreement from June either. I mean, I can see the minute sheet where it spells out everything that was done.
If I may approach.
Yes. May have the maximum penalties reversed, because in the 24 CF 2576, that's the actual felony case.
Let me see that, Your
felony
Honor.
charge. I just want to make sure I'm seeing that. So on the 2456, you've got 1 year.
You're correct.
You can just change it right here. That's fine.
Yeah, you're correct.
Doesn't change anything, Mr. Geist. I just want to make sure that they're
Yes, sir.
flip-flop back to where they should be. 'Cause that was yes, go ahead. Do that. All right, Mr. Geist, if you want to raise your right hand. Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Geist, can you state your full name and date of birth, please?
Austin Gregory Geist, October 31st, 1996.
Okay, and Mr. Geist, did you go over the plea agreement that your attorney has announced?
Yes, sir.
Put your hand down. Did you understand it?
Yes, sir.
Did you have any other further questions about it, now that
No,
it's
sir.
been explained?
No, sir.
Okay, and did you sign that plea agreement?
Yes, sir.
And do you need more time to speak with your lawyer about it?
No, sir.
Are you satisfied with his advice and representation?
Absolutely.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir. No, sir, my bad.
What's so funny, Mr. Geist?
No, I mean, like when you said that, I do got like anxiety.
Okay.
That's it.
He gets nervous, Your Honor.
So is the laughter part of the anxiety and the nervousness?
Yes, Your Honor.
It's a good thing, though.
Okay. All right, and has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement?
No, sir.
And you understand that by entering an admission to your violation of probation, there won't be a hearing of any kind where the state would have to prove how you violated your probation?
Yes, sir.
And it's my understanding you're just admitting to the violations of 2, 3, and 4 on the affidavit, is that right?
Yes, sir.
Correct.
And what's the state doing with the other ones?
The grand theft was previously dismissed, Your Honor. That's why it's written that way.
Okay. So it's not pursuing count or violation 1?
I don't want to speak for the state, but that was my understanding.
Yes.
On the prior, yes.
Yes, okay. All right. And you understand you're waiving all potential defenses that you may have, Mr. Geis?
Yes, sir.
Okay. And so the entry of the plea will be to basically revoke and terminate your probation in the 2025 case, which was ultimately a misdemeanor case. But you're going to go back on probation or community control for a year and then the remainder of probation on your old case. That's what you want to do?
Yes, sir.
Okay. And what is your plea to the violation of probation?
It's admission.
You're admitting?
Yes.
Yes, sir.
Okay. All right. I'll accept your admission as freely, voluntarily, knowingly given. In 25 CF 375, that was an admission to 2, 3, and 4. 1 is not being pursued and is being dismissed. I will revoke and terminate your probation, credit for time served, $100 VOP fee, $150 cost of defense. I'll give you 90 days to pay those costs or set up a payment plan. There is an adjudication of guilt. And then in 24 CF 2576, modify your probation to the next 1 year of supervision will be community control, followed by the remainder of regular supervision. And we're going to add that you successfully complete an anti-theft course, complete all original terms of that probation, $100 VOP fee, $100 cost of defense. Did I get everything?
Yes, Your Honor, I believe so.
Okay. All right, Mr. Geis, I need you to speak with probation before you leave, and you have 30 days to appeal the judgment and sentence of the court.
Yes, sir. Thank you, Your Honor.
All right.
All right.
Have a
All
good
right,
day.
thanks, man.
Yes, sir.
So, Your Honor, I have investigated the conflict in this case for Ms. Rainey's case, and it's 25 CF 1176. We're going to have a conflict, Your Honor, so we are going to withdraw. As soon as I get approval to file that motion, I will file it.
All right, so what are you going to do with Ms. Rainey's case in the meantime? On February 26th, but I'd like to get the case moving. Mr. Kleins can get on it. That'll be your new lawyer from the Regional Office of Conflict Counsel.
Yes, Your Honor, the 26th would be fine. I'll reach out to Mr. Klentz.
He's here today, so they'll talk to him. But until I can actually sign an order saying that's your new lawyer, he might not be able to do anything. So get that to me as quickly as you can, Mr. Maddox.
Yes, Your Honor.
Because he's not going to know anything about it. And they haven't actually filed the motion yet, so I haven't signed the order yet. All right, February 26th at 9 o'clock. Thank you, Ms. Rainey.
Well, two of them are bond motions. Rubley and Santos are bond motions, and then you said you had Spara. Call out Spara. Hey, Mr. Sparrow. Your Honor, this is Mr. Sparrow before the court in 24 CF 561.
Mr. Sparrow, up here, please.
Looking for my lawyer.
I'm handling it today for on behalf of Ms. Rivers, okay?
Okay.
My understanding is either an information needed to be filed in this case or it's just an arraignment, and so we're just going to enter not guilty plea if an information has been filed, Your Honor.
DOP, so.
Or denial then, yes.
Okay.
What do y'all want to do with the case?
Put it on the 26th, Your Honor, without.
No objection.
All right, February 26th at 9 o'clock, no subpoenas.
Does the state have an offer that would get him out today? Just to make sure I don't.
No.
Then, yes, the 26th is fine.
All right, Mr. Sparrow, we'll see you back on that day.
Jurors will be up to see you, okay?
No, the state doesn't have an offer right now.
There's nothing to resolve anyway, sir. I do.
Mr. Spare.
All right, thank you, Your Honor. Okay, I do have Mr. Rubley's bond motion pulled up. Mr. Rubley. Your Honor, this is Mr. Rubley before the court in 25 CF 2339. My understanding is we're here on a bond motion?
Yes.
Okay.
Read the motion, where did it go here? Go ahead.
Yes, Your Honor. So, Mr. Rubley was taken into custody on December 4th of 2025. He's been in the Okaloosa County Jail since that time, Your Honor. The current bond is $12,500 total, I believe, on the charges, Your Honor. Mr. Rubley has represented to us that he's unable to post these bonds. He just doesn't have the funds to do so, and so he's here asking the court to reduce those bonds. Your Honor, Mr. Rubley does have a girlfriend that lives in the area, so he does have some ties to the community with that respect. He would also be seeking employment if he was released, Your Honor. Anything? His girlfriend's name is Savannah, Your Honor. She does live locally in the area. How long? Mr. Rubley has lived here all his life, Your Honor. And, Your Honor, we're asking the court, if it does see fit to reduce the bond today, to reduce it as much as possible, a signature bond if possible, or a lower cash or professional bond so that Mr. Rubley can attempt to coop up some funds, Your Honor, and post it.
State's position?
Your Honor, the state would oppose a modification of the bond amount because this defendant does score out to a guideline prison sentence. In addition, he has prior weapons charges and prior violent charges. He was convicted of a battery. In addition, this defendant might be a prison release reoffender. He was just released from prison 2.5 months ago. Also, the defendant is
2.5 months
homeless.
before the incident, right?
Correct. The defendant is also homeless and unemployed, as reported in his report at first appearances, which would make it difficult for him to make it back to court. And based on the allegations that this was a violent charge where he threatened the victim with a knife and threw a brick, the state would oppose just any modification of that bond.
Anything else, Mr. Maddox?
No, Your Honor.
All right. Based on your prior record, Mr. Rubley, the fact that you just were released from prison, I'm not denying you bond. You have bond. It's $12,500. I think that's more than reasonable. So I'm going to deny the motion to modify your bond conditions.
Understood,
your
Your Honor.
bond amount, so 12,500 will stay where it is.
Thank you for your consideration. All right, good luck, sir.
Do they do for status, I guess, of my response? Do we set it for the 26th?
It's up to you. I mean, if you think it's gonna, you can get it by the 20, I'll leave it up to you. I'll defer to you. He's under a 10-year prison sentence. So, and we're not attacking the prison sentence or the length of probation.
Who's representing?
Is it difficult to say quickly?
I'll give you a synopsis.
Who's handling the pretrial detentions for today?
I am, Judge.
Okay, so you've got Michael Jackson, who is already your client, right?
Yes, sir.
And then there's Susan
Miss
Slingerland.
Slingerland.
Do you guys want to try to do those early, since it sounds like the state's not pursuing pretrial detention?
Yeah, that's fine with me, Judge.
If they're here.
Mr. Williams told me that Dominic Isaac at 1:30 is
We've reached an agreement on it, Judge. I went out and
Let
had
me
it
see if we
signed
can
off
get through the rest of
yesterday.
this, because I want to make sure, because it sounds like this afternoon's going to be another typical afternoon, especially with a lengthy 12:30 hearing for,
It won't be one of mine, Judge.
no, I know. Other people have cases on the docket, Mr. Williams.
I was so happy to see that.
I'm fine with that. I just, I think we all need an actual lunch break today, because this afternoon is going to be probably how it normally is.
Yes, Your Honor.
Yes, sir.
Certainly appreciate that.
I think last Thursday we were here till almost 7:30 at night, so.
Yes, sir. Okay.
All right, Mr. Kleins, you say fell? I think you've got another fine or two you've earned this morning as well.
Oh, lovely. Okay. Well, this is Mr. Fell, Your Honor. I did provide Mr. Fell the copy of the motion that I have written. He's okay with me filing that. I've already emailed my assistant and asked her to e-file this today. And I copied Ms. Leone on that, so she has a copy of the motion before it comes through the official process. So I'll kind of turn it over to the state, and future control date or whatever the case may be, I'll defer to the state on that.
Yeah, Your Honor, that's what I was gonna ask, if we can have a control date. In the meantime, I will provide a response, because it's my understanding that this can be handled without an evidentiary hearing.
If y'all want me to look at it that way, I'm always fine to do it that way.
It's a pure issue of law.
What? Of what?
Of law. I'm sorry,
Okay.
yeah.
And this is that Gould case again?
Yes, Your Honor.
Well, if you could, Mr. Klein, send my office a copy of your motion, that way I can see it right away.
I'll do that today, as soon as I sit
And then
down.
Ms. Leone, as soon as you have it, if you could just send me your response directly, and then I'll take a look at it and get to it as quickly as I can after that. I just can't say where I'll be at the time that I get those things.
Sure. Well, I'll email Your Honor the motion today, in 5 minutes.
I'll tell you how I normally do things. If I'm going to do it based on reading just the motions, I wait for them to both come in before I read them.
Oh, fair enough. Yeah, certainly.
Otherwise, you've got a captive audience without a response for, in the next week or so. That's not very fair.
Actually, I've never thought of that, and that sounds about
Plus,
the fairest way.
I'm
you
gonna
can do
have,
it.
if I read it now, I'm gonna have to reread it a week from now anyways, but that's the way I do things, just to make sure I can be as fair as possible.
Yes, Your Honor, thank you.
So let's put it on the 2/26
That would
at
be
9 o'clock, just so I can have a chance to read it and hopefully make that decision. Just when you send it to my office, for both of you, make sure that Ms. Rhodes responds that she received it.
Yes.
I don't want to be a situation where it gets lost in some junk mail or whatever.
Will do.
Yes, Your Honor, will do.
All right, so, Mr. Fell, we'll see you back on 2/26 at 9 o'clock. I should have a decision by then, assuming they get it to me in a timely fashion before that, and I've got the time to go through it before then. I should, just depends on when I get it.
Understood.
All right, thank you, Mr. Fell. See you in 3 weeks.
You got to do, Trayvon, sorry. Yeah, it's the only one. Let me talk to the state real quick. see she was on the docket. Yeah.
And Mr. Kleins, there was another case you're ultimately going to get appointed to, but they haven't given me an order yet, so we just passed it, and then we'll send you notice once that
Okay.
happens. That was Glover.
Your Honor, this is Trayvon Ditto in 25 CF 2284. Just to kind of speed things up, I talked with Mr. Sprouse. The state would concede that any uncharged conduct should not have bonds on them. So the state would go ahead.
That seems to be a new issue that we have to deal with, because
Yes.
I think on the other case that Mr. Maddox is about to do is the same issue where the state didn't charge, but are y'all entering any sort of, it used to be you always just filed an information and then the clerk would list them as no action. So this is just another new wrinkle with the new jail system, I guess.
I know on the south end, I definitely have had situations in the past. It's not common, but it does happen from time to time. Things slip through.
This is the second one where it's an issue in the past 15 minutes.
Okay, well, then maybe it is.
So I'm concerned it's going to be a new trend.
So ultimately, that leaves a $25,000 cash or professional bond. I talked with Mr. Dido. He's been in custody since late last year. He is, recently, he had 2 children born. He is the sole provider. He works at Zaxby's. That is the primary reason we are asking for reducing that cash or professional bond to a $10,000 signature bond, in addition to probably pretty good prospects on a motion to suppress, given the case law that's mentioned in the bond motion itself. But that's simply why Mr. Sprouse had indicated he would potentially agree to a reduction in the cash or professional aspect. Mr. Dido's just been in custody for too long. He doesn't have any money right now. He does have a job waiting for him at Zaxby's when he gets out, but he doesn't have anything to put together. Plus, he's got 2 new kids that were born, I think, within the past month. So that's why we're asking for reducing that $25,000 cash or professional to a $10,000 signature.
We would object to a signature bond, given the charges, sale, manufacture, deliver cocaine. What's alleged is he was out and about at like 5 o'clock in the morning. I think $25,000 is more than reasonable, especially given the fact that there were other potential charges that he could have received bond, but the state decided not to file on those. So
Why did
that
the state not file on them then?
Nope. So the bond is reasonable because there's only 1 charge instead of 5.
Why didn't the state file on them?
I can't answer that. That was before.
Okay, well, I'm assuming that the state didn't file on them because they felt they couldn't prove them.
That would be fair. So as the bond is currently set, we think the bonds that have that are attached to the uncharged should be removed, and the $25,000 should remain the same.
Your Honor, I was just briefly, last thing I'll say, I was going through the discovery to see if I could find a score sheet. Mr. Dido has told me point blank he has no prior record. I don't have a score sheet, so I can't see that, but I did want the court to be aware of that. That's what he is advising.
He had a pretrial intervention agreement last year. That's what I have for his criminal history.
was the passenger in the car?
My understanding, Judge.
Police report seems to have cut and pasted a lot from the co-defendant, and it's really hard to understand exactly what happened here.
Mr. Dideau is indicating he was a driver. So, it's in full candor to the court.
I've got seemingly pages that list. There's sections of the report, at least that I have, that says that the defendant was placed under arrest without incident. She was transported to the Okaloosa County Jail, so it seems like there's some cut and pasting going on here between reports. Making a $10,000 cash or professional bond.
Thank you, Judge.
Based on the lack of history.
Your Honor, I was looking at this case. This is currently on the docket for the end of the month for pretrial conference. I was just advising Mr. Dideau, we need to take the deposition of the officer here in anticipation of a motion. So I would ask the court to continue this to the
Any objection to that?
No objection, Judge.
I understand that would waive your right to a speedy trial, Mr. Dideau. All right, I'll put it on April 29th at 9 o'clock. However, if you ultimately do bond out Mr. Dideau, you'd be April 27th. We do all the out-of-custody people on Monday, in custody on Wednesday, so just make sure you stay in touch with Mr. Kleins, and he'll make sure you show up at the right date.
That's your court date, and that's the bond amount. Okay, so I'll keep tabs on you if you're still in jail. I'll talk to you. My card still? Yes, sir. All right. If you want. That's all I have on the morning docket, but I know I was just appointed to somebody, so I'm going to potentially go talk to them.
Okay. All right, do we need? You want to do Santos?
Yes, Your Honor, ready to proceed.
All right, so this is 2025 CF 2257, State of Florida versus Mark Anthony Santos. We're here for a bond reduction. I think it's previously stated by Mr. Maddox, the state only filed on count 1, which is the battery by strangulation. So he shouldn't have a bond on count 2 because it hasn't been filed on. We'll make sure that's clear in the order from today. So we're really just talking about the $3,500 cash or professional bond on the domestic violence battery by strangulation. Go ahead,
Correct,
Mr.
Your Honor.
Maddox.
So, Your Honor, he was taken into custody on November 10th of 2025, is my understanding. Now he's only facing the battery charge, as the court just mentioned. Mr. Santos is on Social Security disability. He does have family in Alabama, in full candor to the court. Bondsmen are apparently unwilling to bond out individuals when that is the family dynamic in terms of being out of state because the collateral's outside the state of Florida. I'm sure there are various reasons they do that, but that does make it a concern for Mr. Santos because it implicates his ability to obtain a bond from a bondsman, Your Honor. He does not have the funds to come up with the $3,500. So we are asking the court to lower the bond to a signature bond or to a lower cash or professional bond if possible. Mr. Santos, as mentioned, doesn't have the funds nor the assets to come up with that kind of bond, Your Honor. I missed.
And Your Honor, the state would leave it to the court's discretion. The victim has been contacted and does not necessarily oppose a modification, but just is concerned with the defendant's mental health status, just wants to make sure that if he does, I don't know what's part of the bond now, but what the victim is requesting that he be ordered to take his mental health meds as prescribed And the victim also does not want contact and wants no trespass which, I mean, would be covered by the no contact order.
Your Honor, so I have spoken with my client. He has no objection to the court in entering an order, modifying the bond, putting any sort of mental health pretrial services conditions that the court would see fit to do here, Your Honor. One thing that I did not mention to the court is that it's my understanding that Mr. Santos has no criminal history, so that we'd certainly request the court take that into account.
At a summary of the pretrial services screening report, which seems to indicate that he does have history.
When is that history from, Your Honor?
NCIC shows prior charges of DUI, assault, and battery between 1992 and 2015.
Your Honor, he does recall some of that. He apologizes for the misunderstanding.
Where was that?
Where was?
Where was the prior history from?
You can answer that, sir. Go ahead. Just don't talk about.
I believe it was in Georgia. Well, I lived there for a while.
Where's your client going to live if he's released in some way?
You can answer that then.
My family in Alabama, Deatsville, Alabama.
I guess that's part of the concern that the bondsman had, that the court now has, is that he's saying he's going to go reside in another state.
Yes, Your Honor, but he would also indicate that his family does have the means and the ability to get him to and from court. So while we certainly understand the court's concerns there, I don't think that he's a flight risk. Despite that, I do think that he would still make his court appearances, Your Honor. He does take this very seriously and does wish to address these charges. $1 a day.
In response to that, if I may, then we would ask if, even if the bond isn't modified, if we could add the bond condition if he maybe just, because I'm seeing he doesn't have a number even to be contacted at, that he have to supply some sort of way he can be contacted, either by phone or an address where he's going to be living, so that we have an ability.
His bond conditions already include mental health pretrial supervision, which would require him to continue any psychiatric treatment, take all medications as prescribed, comply with all recommended treatment, no contact with the victim, not to be within 500 feet of the victim's vehicle, residence, or employment.
My client would also wear a GPS monitor, given that's feasible at $1 a day, Your Honor. He has no objection to that.
All right.
We would ask for a signature bond, though, if all of these circumstances are in place.
Is it domestic?
It is not. Well, my understanding is it's not. It's a roommate situation.
That's what I've seen. That's why I'm asking the question. I just want to make sure everyone agrees to that, because that's what seemingly is indicated in the report.
So, no, it's not domestic, Your Honor.
Well, technically, if they live together, but it's not.
Well, but they're not living together as a family. Roommates are not a domestic situation. Based on, unless there's new case law on it, that's how it's always been treated in domestic violence court as well.
Yes, Your Honor.
In fact, it used to be that you couldn't get this charge unless it was DV, but that's been changed. I'm going to make it a $3,500 signature bond with the mental health pretrial services. You're going to have to call them once per week to check in. You're also going to have a GPS monitor that you have to pay $1 per day for. and you won't be released until they can come put that on you. So, Mr. Maddox, you might want to reach out to pretrial services to make sure they know to put that on them. Otherwise, you won't be released until that happens.
Yes, Your Honor.
I want to make sure it's clear in the court minutes that count 2 was not pursued by the state, so there shouldn't be any bond holding him on that case. So it's just the $3,500 signature bond. Make sure you comply with the mental health pretrial services, Mr. Santos. No contact with the alleged victim in the case. Don't go within 500 feet of that victim, the victim's vehicle, the victim's residence, or the victim's place of employment. You understand all that?
Yes, Your Honor.
Okay.
Yes.
Anything else?
Yes, Your Honor, just to make sure, what is his court date set currently?
Oh, I'm sorry. Let's see. I've got it listed as a pretrial conference. We'll move that to February 23rd at 1 o'clock.
All right. Yes, Your Honor, 223 at 1.
Since you said it won't be any issue with him being here for those court dates, I don't expect I'll entertain a Zoom request.
Okay, so you need to be here in
You'll
person.
have to be here, sir.
I'm sorry?
You need to be here in person.
I'll still be in jail, correct?
No, you're going to be released just once they put the GPS monitor. 223, you need to make sure you're here in person per the judge's order.
I'll be released.
As soon as they install the GPS monitor on you.
How do
So
I-
it could be
how-
as soon
how-
as tomorrow, most likely.
How do I pay the?
$1 a day, though. I'm sure they'll tell you about that.
How do I pay
There's no cost. It's a signature bond, so it's only if you don't show up to court, you'll owe the money.
the? Oh,
You need to make sure you're here in person on 223 at 1 o'clock.
223.
Yes, sir.
Okay,
Or you're going to be taken right back into custody.
okay.
All right.
But I'm
Thank you,
allowed to
Mr.
go
Santos.
stay with my family?
Yes,
My
sir.
sister?
Mhm.
Okay.
All right, who else do we have?
Thank you, Your Honor.
Thank you.
Thank you, sir.
Head back.
Thank you, Your Honor.
We haven't- Has anyone talked to Mr. Cobb about Ricardo Bryan?
I called and left a message yesterday to try to figure out what was going on, but I didn't.
No, Your Honor.
Oh, you don't even have them. Oh, it's your case now?
Well, actually, that's something I was gonna ask to approach on. It's actually gonna have to go to Mr. Sprouse because I could approach and explain.
It's fine, but I think I know what the issue is from previous. Oh, it's from the original case.
Well, the original, as well as I was at one time appointed as defense counsel.
I thought
which
so,
wouldn't
okay.
Normally, like, that's not
I've got it.
normally an issue, but with that coupled with the other, it's just too much of a.
Yeah, I think so. I had it listed as Mr. Sprouse anyway, but. So I'll reach out to Mr. Cobb to see where he might be for today. I think it was just status as to what's going to happen with the case, but wasn't Mr. Bryan back here? I understand, but he's been back for hearings.
I don't think there was
Could have
any sort
happened
of-
and no one will tell us because you can't look it up ourselves, so.
I didn't see an order to transport for this specific hearing, and
think
from
you-
what I could tell.
Because I'm looking on DOC, and in the confinement status, it says not in confinement. That usually indicates they're out at another facility. Can you reach out to the jail just to find out if they can actually say if he's there or not?
Your Honor, I may, can I make an announcement on it?
Sure.
Okay. Christopher Estrada is a VOP arraignment set for this afternoon in 23 CF 2629, and the state would just like to announce a dismissal of that VOP.
Oh, that's the one where you had to do like the impound or something like that?
And
Okay.
that was the only violation, and he's shown proof that he did not have a vehicle to impound.
Which is why I gave him a bond on his VOP, so. I'm assuming he's still gonna be here this afternoon, except for 2 o'clock for some reason. That's my mistake. I just signed it the way it was listed, but.
The reason I wanted to go ahead and announce it, I mean, I haven't spoken with this person, but it doesn't show that he has an attorney.
It doesn't.
So I just wanted to announce it in case, I didn't want him to get I don't know if he'll show up, but.
When we start the 2 o'clock docket, can we see if Christopher Estrada is here and remind me if I forget? Because they're dismissing his VOP. I don't want him to sit here for 3 hours because we all forgot to bring it back up. So I'm just kind of throwing it to everybody. Mr. Klein's is talking to Chapman, right? Mr. Kleins, are you on that, is it break?
Yes.
No. And that's gonna be a hearing today?
My understanding, I haven't talked to Ms. Glisson in a couple of days, but yeah, I'm expecting a hearing.
Okay.
So,
I'm just trying to figure out timing.
I don't know who told me this, but for some reason, I have a feeling that there were gonna be a number of witnesses. Like, I mean, I'm certainly not gonna tell the state who they can and can't call, but, and I don't know why I would have thought this or been under this impression, but I would expect it's probably gonna be not a short hearing. So, yeah, that's.
Seeing how it's all gonna, we're trying to do the other pretrial detentions.
Oh, I saw.
As soon as they get here, so we're trying to take care of as much of the afternoon as we can.
Yes, I have not directly asked Ms. Glisson, hey, how many people are you putting on the stand? But, and I don't know why I would think this, but I would expect there's going to be, I mean, there was at least 3 eyewitnesses, you know, plus any officers and all that. So.
That's what he's listed as, but you see where it says not in confinement there? Discipline, okay. Yeah, that's. It says visitation.
Honor, I spoke with Ms. Rivers about her other cases, but are there any motions that I'm missing just to make sure none others that you're aware of that were set for today?
I don't have her listed for anything in the afternoon as far as hearings, just arraignments.
Okay, that's my understanding. I just wanted to make sure. Didn't want to have another motion like that. Okay.
No, Ms. Chapman, I just talked with her. If we could leave her case on for 2/26 without subpoenas, I think we should get it resolved that day.
All right. 2/26 for Ms. Chapman, 9 o'clock.
And then the last thing I have before I'm done for the morning, it's not on the docket. There's a situation with a juvenile that I represented this morning named Javon Blackwell. Mr. Blackwell is in the Santa Rosa County Jail. He was sentenced to 4 years in prison in late January. He has a pending new adult charge here, 25 CF 1315. My concern with Mr. Chapman is that he's going to get sent down the road and there's going to be a...
Chapman, was it Blackman?
I'm sorry, Blackwell. Yes.
Okay. Thinking.
Okay. When I looked the other day, there is no attorney assigned to Mr. Blackwell in that 1315 case. And this morning, I had advised him, like, hey, let me see if I can get on the case because I don't want you going down the road with a hold on you. Like, it's going to mess up your classifications and all sorts of things. So I don't know if this is possible, but and I asked Judge Gonteric to appoint me to this case, and he's like, I'm not doing it. Go ask Judge Oberliesen. So I just want to see if and my agency will not let me do anything on a case unless we've been appointed. So I don't know if the court can appoint the public defender and then they can file a motion to withdraw or what.
What was the case number again?
25 CF 1315.
Trying to just look up him so I can see all of his cases, but it's taking forever, so.
What was the first name?
It was a direct file capias that was done. It just he hasn't been brought here on it.
Right, and my concern is that he's not going to be brought here and they're just going to transport him to DOC. I just want to make sure that we can get this 1315 case resolved somehow.
With concurrent time.
I just want to make sure he's over here so we can get this squared away. So I was just going to ask the court if it's possible to just direct appoint my office to Mr. Blackwell.
I think the problem is that JAC doesn't like that.
That's why I know there's things going on behind the curtain. So would the court appoint the public defender's office?
Yeah, there's, I have no it'd be my case, Your Honor. I have no objection to being appointed on the case, filing a motion to withdraw due to the circumstances, and having Mr. Klein's appointed. As soon as we get an actual file to withdraw from, I can file the motion and get that done. Unorthodox.
Problem is there's nothing, his case is just still in direct file capia status. So I'm not even sure under what vehicle, I mean, I can appoint the public defender. I guess I can issue an order appointing them a public defender, even though it's not going to. Because it's not on the docket, there's no minute sheet.
Right. I don't know how we can, I just want to make sure that we get it done, you know? And I can't even give the court like an order to transport because I can't, legally I'm not allowed to write it up.
Do you know he's still in?
He's definitely in the Santa Rosa County Jail right now. He appeared by Zoom this morning in front of Judge Gonteric.
Can they not serve the warrant at the other jail? Or they can't, or
They won't do it until he gets here.
if it helps, there are, in the interest of justice and in full disclosure, there is a line of cases out there that say basically speedy trial will run the entire time that Mr. Blackwell is in the Department of Corrections because the state now knows where he's at. So, I mean, if he goes down the road with a hold on him, he comes back 4 years from now, the case is going to get dismissed for speedy trial purposes. So if the state has an interest in securing a conviction here, I mean, we need him here, you know?
Right. The state has no issue resolving the case. It's just the process of getting him here.
I'm gonna do an order to transport him here for my case.
Okay.
Once he gets here.
Perfect.
We'll resolve this thing.
That's all we needed. We needed to go through first appearance.
Assuming my order's followed. You know, when it comes to transporting people.
It's hit or miss, I know. I appreciate everybody's assistance with this. I just didn't want this individual to have to stay inside the fence line or something when he's down in the DOC. Yes.
You know, there was a bill last year that would have given us a better mechanism to bring people back and handle cases while they're in DOC, instead of having them serve their time and then be transported back and starting from afresh, which, I mean, there's arguments both ways on that, I'm sure, but it didn't even get a committee hearing.
I was going to say, it probably didn't make it out of committee.
And I don't believe it was refiled this year, because I haven't noticed it, and I'm on a legislative committee, so.
Sometimes I wish the legislature would cross the street and go over to the courthouse and talk to the state attorneys and public defenders. I know. It's an easy right thing to do.
I wouldn't make it 10 days.
We'll all talk offline, maybe.
So I'm not appointed, Your Honor. You're just ordering that he be
I'm gonna order
transferred.
him to come over here, then that will allow them to serve it, and then I'll appoint you, and then you'll withdraw, and then I'll appoint Mr. Klein.
Yeah.
And then
I'll
we'll
go
have-
ahead and try and get.
Since he's
like
already
a-
doing a DOC sentence regardless, it's, I mean, I hate to make it sound like time's not of the essence, but it's the only mechanism I have to really do it, is just to have him transported over here for this case.
Judge Drake sentenced him to 48 months, I think on January 28th or 27th, or the last week of January.
Judge Drake and I have discussed these issues too. It's always, he can't really issue an order saying, get him out of my jail and put him in their jail. He has to, you know, it's easier for, it's more of a pull than a push, I guess is the best way to describe it.
Yes.
We've had these situations before where we've had mutual defendants and how we can make it happen most easily, and it's, if everyone follows the orders, it should be pretty easy.
Well, the ironic thing is in juvenile court, it's crazy to me how they just transfer kids all over the state, and you can send sentencings off to different counties. It's wild in juvenile court, but.
Thank you.
All right, I'll try and keep this one on my radar, Your Honor.
Okay.
I'll bring
Do we have?
Judge, this is Michael Jackson, 26 CF 229. He was scheduled for today for a pretrial detention hearing. My understanding is that the state has not filed and is not going to. He has another case that's pending. The court's got a motion under advisement.
From last week.
Yes, sir. And
I was hoping to do the deep dive on that yesterday, and unfortunately, it just.
I understand, Judge.
Stacked up, and I wasn't able to get there.
So he's here.
I actually started the research because Mr. Klein brought up the same issue for his bond issue, right? The odor issue.
Oh.
And frankly, I just want to do a deeper dive through the change in case law because I don't want to go into it right now, but I think there's more research for me to do.
Yes, sir. And I'm not trying to push the court quickly on that. We now have this to deal with. So he's here for a bond hearing. Right now, his bond is revoked on the case that we had the hearing on last week. And honestly, I don't know that he's going to be able to make much in the way of bond on this. I'll ask him some questions so the court can make a decision on it and issue a bond on it. I think for our purposes right now, though, he's going to get involved in probably ECLC, something like that while he's in the jail. Try to. I think there may be a waiting list still.
I think I have to set a bond, and he's
You do, Judge.
entitled to one, so.
You do. So if I can inquire, does the court want to swear him?
Oh, you inquire of Mr. Jackson,
Yes.
raise your right hand. Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Sir, I do.
Okay, go ahead.
Mr. Jackson, please state your name for the record.
Michael Lynn Jackson Jr.
All right, Mr. Jackson, right now, you've got a no bond, but there's not going to be a pretrial detention hearing. The state's not going to seek pretrial detention, so we're here to establish a bond for you on the new case. How much bond on that case do you believe you could make?
Sure, because I'm currently unemployed, so.
All righty. How long have you lived in this area?
Currently, I've lived here continuously for about since I was 26, I'm 43, so almost 20 years.
All righty, sir. And what, do you have other family in the area?
Yes, my mom, my sister, my son.
All righty, sir. Judge, that's all I have.
The state has no questions.
Any other evidence to be presented?
No, Your Honor, not from the defense.
Ross, anything?
Yes, Judge. The state would ask for a $50,000 cash professional on the trafficking and meth charge, $50,000 cash professional on the possession of fentanyl with intent to distribute, $2,500 cash professional on the POCS, and an ROR on the possession of paraphernalia.
Judge, the defense would suggest if $50,000, but break it down where it's distributed between the three charges.
All right, well, based on the fact that he's already on bond for a similar offense, it's going to be $50,000 each for the trafficking and the possession with intent, $5,000 for the possession of a controlled substance, and I will ROR him on the paraphernalia charge. So it's a total of $105,000 cash or professional, Mr. Jackson.
Yes, sir.
And obviously, he's being held without bond on this other case.
Yes, sir. So once
Thank you,
we get
Judge.
discovery in, or once we get, I'll come out and see you again and go over it. Okay.
All right. Thank you, Judge.
Thank you, Mr. Jackson.
Lingerland, come stand right here. They have not filed a motion for pretrial detention, so today's going to be a bond motion for you, okay? Judge,
Can I just put it on there? So at first appearance, the judge said they have 72 hours to file it. Today's the third day. They haven't filed it. They're not going to file it, right?
Correct.
So I believe the bond's already been set.
all right, Judge.
$50,000 for the trafficking, $5,000 for the paraphernalia.
Thank you,
Total of 55. Now, if you want to file a bond motion, you certainly can, but that was ordered the order of the court. And frankly, as of Friday, I'll be trying to set up a meeting with y'all's offices to talk about this potential procedure of how we're going to do that going forward. So I'll be in touch with the supervisors from both state, or not, I guess, all three of the state, the PD and RCC, to discuss that issue, to see if there's any concerns on how we're going to do those.
Yes, sir.
To avoid these situations where people are sitting in jail for 3 days just to have a bond hearing.
Yes, sir.
So, all right. So that's the bond as issued at first appearance.
So that's what we discussed.
Thank you, Judge.
Okay, thank you.
Thank you, sir.
All right, thank you. All right,
And,
anything else?
This will be Lisa's case going forward.
All right, anything else for the morning?
Unless Isaac's here. Okay.
All right,
Nope.
then we'll be in recess until 12:30 for pretrial detention hearing on Mr. Brick.
Yes, Your Honor.
All right,
Thank you, Judge.